Good afternoon. You are live on Working For You.
Hello, Mr. Byron.
Hi, good day.
Yeah, good afternoon. One of the problems let people have with the behavior in the house,
Yes.
which is, I must say, is very deplorable,
Yes.
is that ordinary people cannot understand the laws that are being laid down in the house. They cannot follow what is going on in the house because of the load of confusion. Every minute somebody rising on a point of disruption.
Yes.
People cannot follow the laws, and most of them apply to the ordinary poor people, ordinary lay people.
Yes.
Right. One of the things I want you to clear up for me is the last law you were talking about there when somebody leave the estate,
Yes.
intestate.
Yes.
Now, suppose the person had a plural amount of offspring.
Yes.
Would the same documents you could get could be applicable if the estate could be dividable?
Yes.
I want to know. For suppose okay, then one was to get the bank account, another one was to get a car, another one to get a piece of land, one a house. How would you deal with it? Explain it for us.
Well, we don't have enough time today.
Okay, cool.
But it's a very good question. It's a very good question. And the Intestates Act that normally would go through the normal process where a lawyer would have to file has laid out in statute very clear precedents of who gets what. Your wife, the spouse or husband, would normally get 10% absolutely of whatever is left behind. Your children, and she would also get half of whatever is remaining, so 45% of the 90%, she would have what is called a life interest in the rest of the estate. The children, if there are any, get 45%, the other 45% absolutely to be divided among themselves. So there is a clear list of people in terms of priority that are set out in our Intestacy Act. That is the basis outside of our will, which is very clear. This form, I agree with you, sets out that someone can go and make an application, and the registrar of the High Court should be able to do a due diligence to find out if there are other beneficiaries. Okay? It's normally done in a way. So you can have that. Now, we'd have to take time to explain what are the processes that would happen within the court system. But then it comes down to the registrar, who normally has to, anyway, grant the orders, whether it's going to be letters of administration for a normal process or something of this nature, to provide the representative to question, to make these questions and act upon them. And I agree with you, it's something that can be vexing. When people pass away, siblings tend to squabble among themselves. They squabble with the spouse and that type of stuff. Where there's no spouse or there are no siblings, it can be the parents, or it may be an aunt or whoever it is. But there is, as I say, the letters of administration, they grant the Intestacy Act that states what it is. And this Small Estates Act would then have to be dealt with within the registrar, within that scope of it. So I don't think we have enough time for me to explain it, but I agree with you, it's something that needs to be further explained so that the citizen can understand what their rights are.